All right, welcome. I'm Michelle Rawn with Rawn Law Firm. We're going to be talking tonight about assistance animals, emotional support animals, service animals, and the new guidelines that were adopted in Kentucky to try to help landlords get a more clear direction on how to handle these requests. So I've given you a couple handouts. The first one has the definitions. Assistance animal is defined under fair housing as an animal that works. They provide assistance of emotional support that alleviates one or more symptoms of a person's disability. This is an animal that is not trained. It can be you're depressed and this cute fluffy bunny makes you feel better. That would be considered an assistance animal. It could be an iguana if that's your thing that makes you feel better. A snake. We've actually read an article on an emotional support cow. I like cows, but I can't imagine trying to rent an apartment and say, can I bring my cow? So, a service animal is defined as a dog under the Americans with Disability Act that has been specifically trained to perform tasks for its owner with a disability. So you've seen seeing eye dogs, dogs that help people who are deaf. There are dogs that help people with their balance. These are actual service animals who have gone through a certification and a training to do a specific task for a person with a disability. Now, I know it was all over the news that miniature ponies or miniature horses or whatever they're calling them is a service animal. I have read through the ADA guidelines. They are an assistance animal. So there's a difference. They're not trained, but they get the same protection as a service animal, meaning that if you have a certificate from your doctor stating that you need this animal, you can now take a miniature pony on a plane with you. I do not want to be on that plane, but they cannot deny you. I'm really not sure how logistically this is going to work, but I have read 2 articles, one from Southwest and one from American Airlines, where they have actually had a miniature pony on the plane.
Do you have to show your certification?
Yes. Yeah, to be able to get the airline ticket, to be able to bring them on, you have to show the certification.
Do they have to buy a ticket on the plane?
Yes, they do.
Good.
It's based on the size of the animal you're trying to bring on. If your support animal or your assistance animal, I believe, is 10 pounds or under, it can fit under the seat in front of you. So they've been fighting that you don't now have to buy the seat next to you, and they've been winning that. But if it's over that size, you have to buy the seat next to you so you're not disturbing the person who would have to sit next to you on the plane. So,
And that goes for both classifications.
yes. Reasonable accommodations. This is where landlords get into a lot of trouble. So most recently, one of my clients is transitioning one of her properties to an Airbnb. And she's trying to manage it herself. You know, more power to her. Bless you. And she got an email from an individual wanting to rent the house for the weekend. And he put in the email to her that one of the guests will be bringing a service animal with them and just giving her a heads up. He explained it was a German Shepherd, that they would be bringing a kennel for it to sleep in at night, and her not really knowing the law responded with, well, I need to know what the disability is, why you need this animal. You can't ask that. She asked for the shot records. You're allowed to ask that for an assistance animal, but you cannot ask that for a service animal. So there is a difference between the two. The trained animals, you're not allowed to ask for their shot records. I don't know why the ADA has said you cannot do that, but they do not permit it. But for an assistance or emotional support animal, you can ask for the shot records. You are never allowed to ask what the disability is. Under the ADA, you will get sued and you will lose. But you can ask what the animal is specifically trained to do. So that's our little end run around not being able to ask about the disability. The exception to that is if the person is blind and you know it, you can't ask anything because they're blind and you know it. If they're deaf and you know it, you can't ask. So if it's a disability that you can physically see, you cannot ask any questions about that. You had a question?
So what if, so I had the emotional support and she didn't have the letter.
Right.
So what if they say it's a certified, or it's a service animal, and you ask them what it's specifically trained to do, and they don't really have what seems to you like a legitimate answer. They, like she got all squirrely on me when I asked her for the letter. So what if they get all squirrely on you when you ask them what it's specifically trained to do? Like because then what is the next step to prove it's actually a service animal?
With the service animals, you're pretty much going to know if it's actually a service animal because you're going to be able to tell if the animal is trained when you see the animal. With the assistance animals, of course, they're not trained. So that's where the certificate is more important. If they're getting squirrely, they're going to have to bring the animal with them when they come look at the apartment if it's a true service animal.
Airbnb, where they show up day
Right. With the Airbnb, the problem with that is they don't fall under the Landlord-Tenant Act. They're more under like a hotel. And so it's a broader spectrum that you have to give leeway to. So when she sent back her laundry list of questions, and then she got me involved when he responded back to her and had cut and pasted into his email response the American with Disabilities Act and included his attorney name, phone number, and email address for her attorney to reach out to because she had just violated the ADA. I responded to his attorney and said, this is her first Airbnb. She was trying to follow the guidelines that she thought were for Landlord-Tenant Act, not thinking that this is more of a hotel. And he was like, we understand. We just want to make sure she knows we could sue her right now and we would win. I said, trust me, she completely gets that. But her concern was, what if they bring this German Shepherd in and they destroy my Airbnb? Well, that's why you have a deposit, because they're still responsible for the damages. Just because it's a service animal or an assistance animal doesn't mean they get a free ride and they can trash everything. That's not how it works. So with an Airbnb or with an apartment or a house, you get a security deposit. With an Airbnb, I think you get a credit card for damages plus a damage deposit typically.
People who don't know anything about Airbnb, the security deposit is fictional, it's hypothetical, and good luck getting it enforced.
Really? Because I've rented Airbnbs and I had to give them my credit card information.
They might do it separately.
And they charged me a damage deposit of $500 that
Was it Airbnb or was it like VRBO or HomeAway?
It was my first one I did was an Airbnb, and I've done it through VRBO, and they both made me pay a damage deposit that showed up on my credit card when I looked online and said that they had
And then you got a credit
held $500. Yeah, they had $500 held.
How long ago was that?
April.
So I'm wondering if the individual did it, because by default, Airbnb does not do it. They tell you they do it, they tell you how much it is when you make the reservation, but your card is not charged.
Really?
And so that's why it's so hard nowadays for hosts to get damages taken care of.
Okay.
Because if you, say they had not charged the card, because they don't now.
Okay.
In my 2.5 years, they never have. So that way, when I submit the damages, the client or the guest just declines. Unless
Right.
they choose to. And then you file a claim with Airbnb, but most of those are denied.
Okay.
So it is not as safe as people think it is. And that $1 million is not really there either.
Okay. Yes, ma'am.
Do you use the terms comfort animal and assistance animal interchangeably? as opposed to a service animal?
Well, a service animal is defined.
No, I've got that, but
And assistance and emotional support, comfort, they're all
Okay.
pretty much the same thing.
Okay,
Yeah.
interchangeable.
The emotional support animals are considered like a division under the assistance animal definition. So the emotional support comfort animals, there can be an assistance animal that's not just for an emotional support or comfort, that is actually there for, trying to think the example that they gave us in class. I've messed my papers up. See, I stand here and I play with stuff. The example they gave us in class was someone who had anxiety, and the dog would basically know when she was starting to get anxious and would know to go in. So that was more an assistance animal. The emotional support is there more for people who have depression, and they're there to help work through the depression part of it. So that's kind of where fair housing distinguishes them. And then, of course, the service animal, they're trained to do a task.
Okay, so if you have somebody who makes a copy of a letter that says, people over the age of 65 benefit from having an animal in the house for companion,
That doesn't matter.
that doesn't count as a...
No. In Kentucky, you now have to have a letter from someone that you have a therapeutic relationship with. This is defined by statute, and I gave all of you a copy of the statute. It is a licensed clinical social worker who holds a valid, unrestricted state license in Kentucky and is seeing patients.
Not
It
a
is,
doctor, not an
hold on,
Okay.
a professional counselor, an advanced practice nurse, a psychologist, or a physician. They all have to be licensed in Kentucky. They have to have an unrestricted license, and they have to be actively seeing patients or clients.
And do they specifically have to say that this is like a prescription?
No, it can be on a doctor's. I've seen where it's on doctor letterhead, where the psychiatrist has said, I am actively seeing Mrs. Jones due to her current mental health needs. She needs,
So it needs to be somewhat specific.
yes, it has to state that they have an ongoing relationship and that this animal is medically necessary,
Okay.
either for their mental health or just medically
But it has
necessary.
to
But
say
it
that
has,
it's medically necessary.
yes,
Not that it's a benefit for an older person to have a dog.
no,
Thank you.
no, yes.
So does that mean that a person could, can't just go to one of these people, a licensed person, and say, hey, I need to rent this thing, I'm a mess, will you examine me? Get a letter right then?
They can try it, and I'm sure there are social workers and people out there who, for a fee, will give you that letter.
So is that?
But then,
Would it have to be proved that it's an ongoing relationship?
well, if they go and set up as a patient, how are you going to prove there's not an ongoing relationship? Then it falls back to you. So we've tightened it up because until just this year, they were able to get one of those online website, pay however much money you want, and get this nice little certificate with your animal's photo in it saying that, oh yeah,
Really?
yeah. And that was enforceable. I've had that show up in eviction court over the past 5 years, and we lose every time. And so that's why the apartment association got involved and went to work on fixing our statute and making it where it has to be someone licensed in Kentucky. Yes, sir.
I have properties that do not have accommodations for wheelchairs, do not have grips for in the showers or anything. Can I just stick with that? And if someone needs that, that's their problem.
No. If someone needs it and they make a reasonable accommodation request to you, they have to pay for it, but you have to accommodate it. So if you're able to put the grips in the shower or you're able to put a ramp in, the tenant has to pay for it, but you have to accommodate it. Now, if it's a property where there's no way a wheelchair is going to fit through the front door, you don't have to completely rebuild the front door to make it. That's not reasonable. But if it just needs a ramp going up to it and they ask you to put in a ramp, you have to accommodate that. That's been held to be reasonable. But the tenant has to pay for it.
So yet the tenant has to pay for it in advance. before
It's
they
not
do
held that they have to pay for it in advance. It's held they have to pay for it, which means you have to put it in, and if they refuse to pay for it, then it gets deducted from their security deposit at the end.
Is there anything else like that that we have to worry about on our property?
It's a case by case. I mean, we've had where one of my clients, it was an older woman in a wheelchair, and she wanted them to change the handles that were on the kitchen cabinets because the type that were on, she has trouble with her hands and she couldn't grip them. They were like tiny little knobs, and she wanted them to put in ones that were more like a handle that she could put her hand in and pull them open. That was considered a reasonable request. And so they went through and changed all of the handles on all the kitchen cabinets to that, and they sent her the invoice for it, for the labor and the cost of putting them in. And I think she's paying $20 a month because she's on a fixed income towards the cost of them doing that. But that was a reasonable request. So you have to look at the request to see if it's reasonable. What they hold as unreasonable is, say someone shows up with their emotional support animal and it's a pit bull. And you can tell the pit bull's already being aggressive. And your insurance company has told you, if you bring a pit bull on your property, they're canceling your insurance premium. You're no longer going to have insurance on that property. If you get them to put that in writing to you on your insurance letterhead, so like say it said State Farm Insurance and had your agent's name and said, pit bulls are strictly forbidden from the property, we will terminate the insurance policy, that is considered an unreasonable request and an undue burden on the landlord, and then you can deny, even if it's an assistance animal or an emotional support or a service animal, you can deny it because it's an undue burden on the landlord because you're going to lose your insurance.
Can they pay the insurance premium and bring the animal in?
It has nothing to do with paying the insurance premium. State Farm is telling you they will terminate your policy. There's no amount you can pay to be able to bring that pit bull onto the property. That's an undue burden. If you're able to have insurance and they can bring that on, you can't charge them anything for that. That's the other thing. If it's an emotional support, an assistance, or a service animal, you don't get to charge a pet rent or a pet fee or a pet deposit because it's not a pet. It's an animal that's been basically determined to be medically necessary for a need. So it's not a pet. That's what you've got to distinguish it by. Yes, sir.
Okay, so I'm back to this old practice of these certificates that people could generate themselves.
Mm-hmm.
What happens in a situation where somebody had used that in the past before the laws got tightened up, and they're in a 3-year lease? What happens in the middle of that when that old certificate is no longer valid, that they're already in the apartment?
If they're in a 3-year lease and you accepted that certificate, that's what the law was at the time.
What about the renewal period?
When their 3 years are up, then they have to bring it into compliance, which means they have to get you the new certificate. But during that lease term, so say last year you entered into a 3-year lease and they gave you the online certificate, they're good for 3 years.
Okay. But it's not a forever.
But it's not a forever, no. Hold on, Jeannie?
What about if I have a tenant who was renting already 3-4 months, and they brought one dog, little dog, we allowed, they pay extra. Now she texted me that she wants second dog. I said, we allow one dog in the house, we cannot have second dog. She immediately said, oh, I was thinking to take emotional support dog. I said, but you already have one.
Well, now, if you accepted the one dog, if they bring the second one in and it's an emotional support animal or an assistance animal, they now have 2, and you have to accommodate it. Because you can't deny an assistance animal or a service animal. Otherwise, you will get sued under the ADA.
But they have to show.
But they have to show you the proof. They have to
Or-
show you the proof that they have.
Proof again, I missed that part.
It's in your statute. They have to have a therapeutic relationship, which is a licensed clinical social worker, professional counselor, advanced practice registered nurse, psychologist, or a physician who's licensed in Kentucky and is actively seeing patients or clients in Kentucky. They have to have an ongoing relationship with them, and they have to give you something. It can be a prescription, just something written on the doctor's letterhead.
Be a registered nurse and they can do that.
It has to be an advanced practice registered nurse. So, but yes.
So that's for assistance animals. But for the service animals, you can ask what the animal was specifically trained to do.
Yes.
But
But
on
you,
the
but
other
you,
one-
but you can't ask for their certificate of training on the service dogs. You can only ask what they've been trained to do.
So you have no proof of anything. That's just insane. Okay, you can't ask them what their disability is.
Nope.
You can't ask them to provide documentation from their doctor.
Nope.
But on assisted,
On assisted, you can.
you can ask
Service
them-
animals are held to a higher level of protection because
but
they've.
there should be some, evidence of. I mean, am I wrong? I mean, I'm a
The,
pretty
the,
reasonable
the,
person.
the ADA has said no.
Said you can't ask for any kind of
Nope.
proof.
Nope. You can only ask what the dog has been trained for. Now that's the nice thing right now is still a service animal is defined as a dog. So if they show up with a cat and try to tell you it's a service animal, it is not. The horses are considered assistance animals. They are not under service animals
You know,
yet.
the airline's still fighting that right now.
I know Southwest and American Airlines has allowed them on. So
I just saw something recently about a little pony, one of
Yep.
those little baby
Mhm.
ponies, whatever they're called.
yes, sir.
So after 11 months, you do a walk through the property and it's damaged from that animal.
You can charge them.
You can
Yes.
tell
They,
them that if they want to renew that lease, they got to fix everything that's in there at that point or
They'll pay for it.
So you're denying
Okay.
them a renewal on the lease based on damage, not based on the service animal.
right. Because they're responsible for the damages. I mean, so you're wanting to tell them they have to pay to fix it to be able to stay? I don't know if the court's going to hold that.
What's the proper procedure, I mean, they're responsible for the damage though.
You just make them sign
Right,
a
but
new
they're
lease.
responsible when they vacate the property.
So if I allow them to stay, they're vacating unless they fix it. They can do 1 year lease.
You may have trouble with that one in front of a judge. Yes, ma'am.
Good luck.
You should.
What do you mean an addendum?
Like, they just said, there's an addendum you have to sign, we need paperwork, we need a picture of the animal, name, birthday, and you have to sign an addendum. I don't know where to say addendum, so I'm just wondering if they can do that.
You can have a lot of the major apartment complexes are switching from having, they had a pet policy and a pet addendum. And after taking our fair housing class that we took recently, they're recommending that all of them switch to an animal addendum and an animal policy so that it's across the board, whether it's a pet or a service animal, an emotional support, whatever. You've got the same policy in effect for all the animals so that way they know if you're responsible for cleaning up after your animal. If your animal bites someone, you're responsible for that. If they damage something. And so that's probably what it is just going over the guidelines of what you would be responsible for if the animal does something. Now, if they're trying to charge you rent or a deposit or any sort of a fee, they can't do that. Not when it's an assistance, an emotional support, or a service animal. You can still charge those for pets. So that's what they've told us that you need to put in there, that it's like a non-refundable pet fee if it's not one of the support animals. But you have to have all of that spelled out in your rules and regulations so that way you're covered. Yes, Greg?
At the end of the lease, can you just send them a termination letter saying that they, at the end of the lease, you will not be renewing the lease without any explanation whatsoever? Just
Oh yeah, I tell all my clients when you're terminating someone's lease, don't give them a reason.
Right.
Just say, we're not renewing your lease. Your lease will terminate effective whatever date. But just so you know, if it's one that they pay rent, your 30 days on that termination letter starts running the first day of the month. And by Kentucky law, they have to receive it on the first day of the month. So please do not give your 30-day notice letters to your clients on, say, October 1st and say that it's going to end October 31st, because the judges will throw your case out.
Send it the month.
Your letter needs to be dated at least 3 business days before the first day of the month, because there's a statute in Kentucky that says when you mail a letter, it is deemed delivered in 3 days. Doesn't matter where you mail it from, 3 days. Kentucky gives you 3 days for that letter to get there. So make sure you're mailing it 3 business days before the end of the month. And if you are terminating someone's lease, don't give a reason. If you give a reason, you're opening your door right there for them to come through and say, well, you said you weren't renewing me because of this, and now I'm suing you, or I'm going to turn you into fair housing, or I'm going to go to the Kentucky Commission on Human Rights and file a complaint. Another thing that's going on, just so you guys know, Lexington Fair Housing is kind of merged with Louisville Fair Housing. I'm really not sure how that worked. They are calling property managers and landlords and asking you really weird questions, trying to get you to say you're not allowing pets, and then they throw something in about service animals or assistance animals. And when the landlord responds again, no pets, they are turning you over to the Kentucky Commission on Human Rights, saying that you just violated it because you considered a service animal or an assistance animal a pet and you denied it on your property. Keep in mind, they've never submitted an application. They have no intent to come and live at your property. They're calling.
An entrapment?
It's not held as that because it's not criminal charges. They just want your money. And I've got 3 clients right now, Lexington Fair Housing. I've got 3 clients right now that we've negotiated settlements down to where they were originally asking for $10,000. I've got it under $1,000 on all 3, but my clients are having to pay. The newest one that just started last week is they are now showing up at apartment complexes or calling landlords and saying, how many people do you let stay in a 2-bedroom apartment? The old rule was 2 people per bedroom. That is not the rule anymore. Do not say that. That is a violation of fair housing. The case that brought, quit looking at me like that, Dennis. The case that brought that to the forefront was a husband and wife, second marriage, each had 4 kids from their prior marriage. 10 people. Wanted to move into a 2-bedroom house, but it had a den. And the den had a second door that went out into the backyard and had a closet. And they asked the landlord, could we convert the den to the bedroom for the boys? Dormitory. All the kids were 10 and under. They had 3 girls, 5 boys. They wanted to put the 5 boys in the den. They had 2 sets of bunk beds and a twin bed. It would have worked. The landlord said no. The landlord said, sorry, 2-bedroom house, 4 people maximum, and would not rent to them. He lost.
The landlord lost?
No, the landlord lost. There is no calculation. You have to look at it on a case-by-case basis.
So what's Section 8 doing?
I have no idea. I just know fair housing has told us you can no longer say 2 per bedroom at all.
There's no limit?
You have to look at it on a case-by-case to make reasonable accommodations. So the other case they brought forward was a young couple just married. Their lease was getting ready to renew, and she happily told the landlord she was pregnant. He refused to renew the lease without them moving to a 2-bedroom apartment because now there were going to be 3 people. And she's like, the baby's going to sleep in a bassinet in our bedroom for at least 6 months after she's born. No, he wouldn't do it. He lost. So you have to look at it on a case-by-case basis. And if they want to have the baby sleeping in their room till that baby's 4 years old, that is their choice. And they get to rent a 1-bedroom apartment. Yes. It did because of the house. It had a really big den that was, they were gonna have 2 sets of bunk beds and a twin bed, and there was plenty of room. I've seen the pictures. It would have worked.
So had it been a smaller house.
And that's exactly what they said. They said if it had not had that den, but that house, it would have worked, and it was a reasonable accommodation request, and the landlord flat out said no. So you can. What I've recommended is to say, I need more information. Will you please complete an application or fill out our questionnaire? And they're not going to. My one apartment complex has decided their response is going to be, typically it is for adults, but we look at it on a case-by-case basis. They wanted to have some answer because when they tried not answering, the next day they got 15 phone calls. So it was basically because they refused to answer, they just kept calling and calling and calling and calling and calling them, trying to get them to say something stupid. They're also going into apartment complexes right now. One of my apartment complexes that I do evictions for, they have a wait list. They never have available apartments. And she said literally she was dealing with a tenant who had a huge issue. She was going over his paperwork with him, and some guy stuck his head in the door and went, "Hey, how many can stay in a 2-bedroom?" And she went, 4? I don't know, I'm busy. And he went, "Thank you." 3 days later, they got the notice letter in the mail that there was a complaint filed against them. So these are the games they're playing because they're trying to use it as a cash cow. So, yes, sir.
So you can't just use a no animal policy?
No, a no animal policy is a violation of ADA because it is they consider it to be a reasonable accommodation request. Now, it depends on the animal. I did have one of my clients call me. I joke about the cow. It's true. I had one of my clients call me and say that they had someone put on the application that they had an emotional support cow. The house they wanted to rent was in a subdivision with an HOA. I'm like, you can deny that because the homeowners association will not permit it. It violates the local law. Now, if they had been out in Henry County on a farm and they wanted to move into the house with a cow, that would have been a reasonable accommodation request. In Jefferson County, you cannot bring a cow into a subdivision. So, yes, sir.
Is it a Jefferson County rule or an HOA rule?
Jefferson County has rules on domesticated animals, and a cow is not a domesticated animal. So the ADA says that you have to file the local rules. So if you have an HOA that, say, is in Henry County that says, no, you can't have it, but Henry County doesn't have anything, you're still bound by those guidelines in that subdivision.
Well, like with mine, my HOA says 1 dog, and she had 2 support dogs.
But that's different. That's a dog. That's a domesticated, right. It's a domesticated animal.
One, a reasonable accommodation?
No, if they have 2 and they have the certification for it. Now, if they're like Grand Pyrenees and they're trying to bring like a 300-pound dog into a tiny little apartment, that can be considered unreasonable. But if they show up with 2 little 5-pound dogs and have the certification, that can be so you have to look at it on a case-by-case basis. Yes, sir. I'm sorry. Okay. Yes, Dennis?
So if we get that crazy phone call, do we have the right to ask them if they're working for an agency that is trying to entrap?
You can. They're probably not going to answer you.
I'm sorry, I can't hear you. You said that loud.
He said, yeah, exactly.
What should we do?
As I said, tell them, we need more information. We look at it on a case-by-case basis. Would you please complete an application or a questionnaire? Because it does truly depend on, we have one that they showed up and she got them to fill out the paperwork, and so she told them she was sorry they couldn't be in a 2-bedroom because they had a 15-year-old boy, a 13-year-old girl, and 2 little ones, and then the parents. And she's like, it's not going to work. It's their apartment complex, the 2-bedroom apartment's like 750 square feet. She's like, it's not going to be accommodatable because you have teenagers. So once they're a certain age, they do require them, you can't put the 2 teenage kids because they're opposite sexes in the same bedroom. That's considered an unreasonable accommodation.
You can't ask the age of the kids.
You can ask if they're teenagers. That's not giving a specific age.
Did you ask their birthday?
Yeah, you can ask dates of birth, you can ask sexes.
You can deny it if you got a 15-year-old boy and a 15-year-old girl that can't live.
They can't cohabitate in a bedroom together, no. ADA does not consider that, and fair housing does not consider that No, they just, that was one of the things they said. It all depends on, now if it's two 15-year-old girls, then that's fine. But they say once they reach a certain age, you can't have them together. They won't tell us exactly what that age is because it's fair housing and they're not actually going to help us at all. So, yes, I did say that out loud.
Sense of humor.
I did say that out loud. So, any other questions? All right. Well, if you need me, I will be here. I'm Michelle Rawn with Rawn Law Firm. Thank you.